USCIS drops new rules on releasing derogatory information when they deny a case. This is the new spin that we got last week from USCIS, and we're going to break that down and discuss it today. My name is Sam Shihab with the law firm of Shihab Burke.
Brian Burke from Shihab Burke as well, here in Dublin, Ohio, 6 o'clock on a Monday.
So we're trying to wrap our hand around this rule.
Yeah.
And it seems to me there's something that we all agree to, is that there's basic two fundamental premises.
Okay.
Fine. The first fundamental premise is that you have to share information that you are going to rely on, that you've learned to deny a benefit in general.
Yeah, the government has to, if they're going to make bad decisions against you, you have to show me the evidence. If you're relying upon evidence, give it to me so I can basically look at it, think about it, rebut it.
Yeah, and then the second premise there's no dispute about it is if this information is of national security concern or restriction, something about somebody using something really bad that affects the masses of the U.S., then you cannot share this information because there's impact to other...
As I put it, sometimes immigration has a national security component to it. Not all of it, but there is. And basically, you know, if we got sensitive information from means that we need to keep secret because it's part of our national intelligence apparatus, for example,
so those
we
are
might
the
not
two
share
premises.
that. Yeah.
Those are the two
That was
premises.
always out there in my mind, for sure.
Simple.
Yeah.
Now, what this new USCIS policy that we're trying to communicate to you guys in less than 10 minutes, what this does is trying to deal with the stuff in between. Information that's not national security that they would like to use to deny a benefit, but for some reason they cannot share it because they're restricted by agreement.
So you're viewing it a little differently, because I was thinking that, so you're thinking this information has always been out there, right? And they didn't have a policy that allowed them to use it and not share it because they weren't allowed to share it. And now they're saying, now we can start using this information against you and we don't have to share it. Because in the past, prior to this policy, the issue was, oh shoot, we can never bring that information in because we can't share it with you. Because we can't share it with you. Now we don't have to share it with you and thereby we can bring it in, right?
Yeah, so 2020, Ninth Circuit's appeal court said to the government that you are going to deny a benefit to someone, you must share this information with the person with sufficient details that they are able to explain it, rebut this information, so the government can make good informed decision about the case.
Yeah, I've argued this like tens, hundreds of times in appeals, for sure. It's literally like boilerplate. It's if you're going to make a negative decision, you better tell us what you're doing it based upon. Yeah.
So they're now saying that when we are going to deny a benefit request based on derogatory information of which the requester of the benefit, the applicant, is unaware of, this policy talks about that.
Yeah.
So it's just going to clarify people what this policy talks about. And it's the government wanting to not give you everything because, or use information that they're not able to give you to deny your case.
Yeah.
And that's a dangerous precedent in my opinion.
Yeah, it requires, if you're really trusting of your government to, great, you know, you trust that they're going to act in your best interest, but literally, I mean, this is the sort of thing where when I write an appeal for any sort of immigration case, the very first thing I'm going to do is look at the substance of the notice they sent. And I'm going to wonder, I'm going to look at it really carefully and ask, have they given me all the information that they're really acting upon here? It is so critical, fundamental to understanding how to, if you're going to appeal, or if it's a good idea to appeal, or if you should file a new case, is understanding why you're denied in the first place.
Let's bring it down in context.
This one excites me, Sam.
Let's bring it down in context.
An example? Okay.
With an example so people understand what we're talking about. The government learns that a guy by the name of John Doe committed a heinous crime, okay? And now they have an agreement because they have access to databases and they have an agreement with this agency that they cannot disclose this information.
So they have access to information, but written into the contract for which they get it says, you are not allowed to disclose this information to others.
Yeah. So the problem is this information could be something about somebody who's John M. Doe, And then the rebut say, well, in this government information that you're using, it says John M. Doe, he's 5'11", he's blonde with blue eyes.
That's what happens if you get the record.
If you get the record, you say, I'm John V. Blow, not even Doe, different name.
Yeah, your document's fuzzy. It says Doe. My name's Blow. I'm a different guy.
I'm 6'3", and I am dark complected.
Yeah.
Okay, and I have a scar on my face that's not referenced in the list of, facial features. So that person you're relying on is wrong.
Yeah, but you have the opportunity to challenge it because you've seen the document. Now, in the theoretical future version of the universe, they're going to say, if they're being so generous, they could say, we have information. We know that you committed this heinous crime overseas.
Yes.
All done.
Well, they're saying that they're going to try to give you some information or to try to extract it from you.
Yeah.
They're going to say, back in 1975, when you were in the country of, let's say in Singapore, between March and April of that year, did you do anything bad?
Yeah.
They're trying to get it from you.
Yeah. So they can get it into the record and give you an idea. If they start poking around the area, perhaps they think that's good enough to allow you to know what they're talking about, so to get it into your head, so they don't have to disclose it, but you bring it up, right?
So this policy, it really by itself doesn't do anything, because you have to see how it's applied and how aggressive they are in applying it. This policy, if it's going to be challenged in court, is going to be challenged based on the facts of the case, the specific case. I'm not sure you can take this to court and say this is unconstitutional. I think there's a lot of the court's going to say not enough.
I think you might be able to challenge in the Ninth Circuit, though, where they explicitly say you have to.
The Ninth Circuit had a case about a marriage fraud case with specific facts, and then they came out with rules. So this policy doesn't do anything. It's how they are going to implement it. It could be a horrible policy, or it could be benign and it's really not impactful based on what really happens in this policy. So very difficult to kind of figure out where we're heading from here right now, except to talk about maybe the alert buzzer is start to kind of do a low noise. We're going to get louder if we start seeing cases of denials without giving people the opportunity to rebut this information, a reasonable opportunity. But if they don't do that, we may be okay. So it's hard to tell.
What is that going to look like? What is that canary going to look like? I presume it's going to say, we have information that's come to our attention that we're unable to disclose to you under this policy that gives negative bearing on your case. Sorry, you're done.
There's always been a new reporting with RFEs that talks that way now, that says there's some information on H1B petition. There's some information out there that's derogatory about the beneficiary. What do you know about it? You're the petitioner. Or can you collect information that are negative regarding the beneficiary, or something very broad, which is weird stuff. And our esteemed colleague Joe Morhart was saying it really is related to also AI information that can be collected that can give you broad information, data harvesting information that's coming in that's not really clear, that they can start asking you weird questions and expect
the sort of thing where they can use some sort of algorithm to basically discover an issue and not be able to produce evidence.
Totally speculative.
Yeah.
We haven't really seen it, but this is an interesting area that they're saying, well, this is not national security information. This is really information that we're restricted by agreement. And like you said, what better way for them to restrict themselves is to enter into all these agreements with third-party provider that says, just say that we cannot share this information, so we can not share it.
Hey, I'm the federal government. Would you like a billion-dollar contract with me? Could you put a little clause in that contract that says anything in here that we can't share with anybody else outside the government? Because that'd be awesome for us if we wanted to really basically hide the means by which we're investigating people and denying cases.
But that hasn't happened yet, so people understand. But we're just concerned that this is the next step.
Well, yeah, we're a bunch of attorneys, and maybe we don't talk about it much here, but it's a concept of due process. It's built into our system of laws and procedures is that anytime you file a case, you make your play. Give me a benefit, and they say, well, you haven't met it. Well, but they can't just say you haven't met it. They have to tell you why you haven't met it, such that you know what's wrong and you have the opportunity to fix it. And sometimes it's a very easy question. You didn't give us a medical exam on your I-45. That's a very easy due process thing. You tell us that it's legally required. We hand it to you. You're done. But when they're talking about stuff,
the rules have to be simpler than this. The rules cannot be complicated. If we are going to deny a benefit, we must share the derogatory information with the person unless it's in the U.S. national security.
Yeah.
That is a simple policy. That's a fair policy to all concerned. This makes the people that live in this country feel comfortable that the government is not playing games.
Yeah.
When you start throwing things like this, then saying now we got this gray area in the middle, now how big is the gray area? That big? Or is it that big? And that's the concern. People feel uncomfortable about the government's starting to play games with the rules.
Yeah, I mean, for the U.S. government to say, I mean, I understand classified information, but we have a contract where we cannot disclose. It's ridiculous. It's literally the most powerful entity on the planet. The U.S. government. They can set the terms of whatever contract they want.
The number one thing that USCIS love to do is to say you've committed fraud because you had to enter into a marriage fraud. What marriage fraud? Well, you didn't live with that person for more than 5 months, and you moved out. And there's a reason that happened. No, you committed marriage fraud. All subsequent cases are denied, and that's the 2000
There's I always like it's to connect the dots. There's a series of dots, series of dots, and they ignore the directions and complete the picture in the most evil way possible, and they are very happy to ignore like the innocuous explanation that would align all of those facts as well. Yeah.
So derogatory information policy, just on the radar. I'm not saying that this is going to be a disaster or a big problem for us, but I would say that this is something that to keep an eye on. Let's move on and take questions. We are going to take questions from 2 sources today. From your questions on YouTube that you post right now, we're going to start with these. And then we're going to pick up a couple questions from immigration questions.us. It's a website we own that we typically people will drop questions during the week to get answers. So now, let's take, Brian, the first one from YouTube,
the live questions.
From the live questions, yes.
Yes. Hello, dear professors. Please, according to your estimate, which year or month will the visa bulletin for other workers be issued this year? Maybe the question is, how far is it going to go this year? The visa bulletin for other workers. Maybe that's the question. And I think it's worth, before we talk about the visa bulletin, to give sort of our disclaimer on the visa bulletin. It is sometimes a fool's errand to predict the visa bulletin because as soon as you try to do so, well, there's just so many factors to come into play.
It's absolutely beyond. Nobody has all the information as the State Department.
It's calculated on, and they even calculate it on a month-to-month basis based upon case demand and that thing. But let's look at the concept of rest of the world, other workers.
Rest of the world. So employment-based.
Yeah, employment-based. This is their final action
workers
dates.
right here. So they're saying, I guess he's asking how much movement we can expect this year.
Yeah.
I see it here for 2021 right now, July 2021. That's final action date, I believe, Brian.
That is final action dates, yeah.
What's the dates for filing?
Dates for filing, that's a good way to analyze it. Other workers, July 2021.
So the band is very narrow. They're not anticipating much. It's a week.
I want to unpack what you're saying.
2 weeks apart.
So you're saying, and I agree with you. A good way, what the dates for filing on the visa bulletin are supposed to be is a look forward for the foreseeable future where we expect the dates to go. And if the final action dates are on July 8th, 2021, and the dates for filing are on 22nd of July, 2021, they don't foresee much movement on that for the foreseeable future, which I guess would probably mean for them to the end of the fiscal year would be a conservative way, which would end in September 30th.
I mean, another explanation is that they've dropped the ball on that date because that is extremely narrow. So let's look at another, let's look at other workers, different category, like third preference, May 1st, 2023.
1st of May 2023 is where the dates for filing are.
Yeah.
And the final action dates are April.
Again, very narrow.
Yeah. Well, we are getting, it's, Sam, it's June. This is July visa bulletin we're looking at. There's not much fiscal year left. So these dates necessarily have to,
that makes sense.
Our theory of it is that if the dates for filing are an outlook for the year, naturally as the year goes forward and you run out of outlook, those numbers should essentially come together at the end of the year. So I guess...
So it follows.
And maybe a thoughtful analysis is maybe there's not much space for the for movement until the next fiscal year, which begins in October.
Okay, Zainab Duran.
Zainab.
One of two. My husband and I are currently in the United States on an F1 visa. He got selected in the H1B visa lottery. Congratulations. Cool. And we already filed a change of status from an F1 to H4 for Zainab, obviously. She's Turkish registered nurse, I140 approved in EB3. Priority date is April 2024. Once my H4 is approved, will I have an issue adjusting status through EB3 when my priority date becomes current? So let's talk about the concept of dual intent.
Okay.
The concept of dual intent is applicable to H4 visa, H1B visa, L1, L2 visas as well.
Most common examples, yeah.
And it has the idea of having a temporary non-immigrant intent and a long-term immigrant intent that they can coexist together at the same time.
Sure.
And because you have you are on H4 visa and therefore you are in a dual intent visa, it's appropriate for you to pursue immigration at the same time you're pursuing this H4 visa that you have filed, and therefore I see no issues or no concerns with you pursuing your green card through your registered nurse status, which probably a Schedule A occupation, and then getting that H4 approved.
Well, I was just thinking about something entirely different. Visa screen. I'm seeing an employment-based green card for a registered nurse, and if they're going to be applying for adjustment of status, if you haven't talked to your employer about visa screen yet, do that because you need to have a complete visa screen for apply for a green card as a registered nurse.
Excellent idea.
Yeah,
Brian.
yeah. Fun stuff.
Yeah.
I have one question here from Akash that came in between Zainab's.
Brian.
What is the average time for adjudication after date is current? My EB3 priority date, March 1st, 2013, is current since April 2025 and no movement yet. Boy, that's a good question. Days to months? Fair answer?
So in figuring out the processing time of a petition with the USCIS, they play the biggest game ever. Number one, they don't give you straight answers because they published a number that says we are going to process 80% of that cases within that time frame. So are you in the 20% of the cases? Are you in the 80% of the cases? Who knows? And also it gives you various locations and so forth that they publish from time to time. And therefore, the published time by the government is extremely suspect, not trustworthy, and that's the only information we can rely on anyways. But we can give the best estimate based on the most ridiculous way of calculating processing time that the government give us.
Yeah, I have an anecdote. I got an EB1A I140, hard fought for a very nice guy. He had an older EB2 priority date. And right when we got the EB1A approval, he also had a medical exam RFE on his I45, which are outstanding from the EB2 category. And literally, probably maybe about 2 weeks after his EB1A was approved, I guess USCIS figured out, or maybe he sent they figured it out immediately and approved his green card in the EB1A category based upon the fact that, well, they figured it out. But sometimes, they just have trouble figuring it out. And sometimes you might want to send them a letter, find an excuse to send them something to poke them,
I would also add that it is a little bit of a luck situation. For example, right now, it's the end of the fiscal year, and if they're rushing to approve cases before they run out of the fiscal year because they cannot carry these visas to the following year, they can just say, grab this box of cases, let's get them approved, I mean, this is how we envision, because we really have no other way of figuring out why certain cases get.
No, I'm 100% said. Your vision is reality.
They grab these cases, they slam that box on the desk, and they just grab these files and they drag them, look at them, quick review, and go in and pull a number and approve it.
Oh yeah, I mean, think about like the.
And the next box sitting next to it, Brian, can sit for the next 1.5 years.
Think about the post-COVID big visa availability, thing. People with 2014 priority dates got approved, while 2013 priority dates, well, they're still waiting. So it's 100% a real and true thing.
Yep.
So let's see here.
Just remember, immigrationquestions.us. So let's go ahead and quickly answer a couple questions here from online since we started.
Okay. Yeah.
And then we are going to take it to immigrationquestions.us because there's a couple of them. And those from immigrationquestions.us who we do not answer your question live today, you will get an email from us by tomorrow with your question answered. Yeah. Just to let you know. But back to the next one here, I think.
Well, question from Ranyan. We're waiting on an MTR, 180-day deadline coming up soon. Probably an unlawful presence issue they're thinking about there. If we sue USCIS, will they start back again and stop processing? Can a judge speed it up? I guess a judge doesn't necessarily speed up a case in a mandamus filing, for example, but the lack of desire for the government to have a drag-out fight in court is something that can speed something like this up, is the bottom line. So, it's the sort of thing you have to really talk to your counsel about very carefully.
Yes. From Ahmed, when a priority date becomes current in I-45, when do I expect to hear a decision? Did we answer that one?
Yeah, well, I mean, from a different person, but the same sort of thing. And the answer is, it varies, and sometimes it takes a little bit of luck. You might have an excuse to give them a poke.
Sounds good. So next one here. Can we get medical RFE even after the interview is completed? Interview was done when date was not current. Now case remains pending. Medical RFE can come in any time. Absolutely.
I mean, I have been to plenty of interviews where it's, we're going to send you an RFE about this after the fact,
Ahmed Hamad. Lost my job on H1B. I'm very sorry to hear that. When I was overseas and I entered on national interest with advanced parole, the embassy outside the United States asked me for my passport for stamping after being admin process for 7 months. How should I respond?
Seems like a pretty...
just reply to them that you're not interested in pursuing the stamping at the present time.
Yeah.
Very simple.
Yeah, you're not entitled. I mean, you shouldn't be getting that H1B stamp anyway if you're no longer employed by the company there.
Yes.
So we're going to check some of those questions from immigrationquestions.us here, and I'm going to do my best to put it up on the screen here as well. It's going to take a little bit of finagling. Just take a second, though. Going to add one here, primary text. I didn't copy it from here properly. There we are. Yep, there we go. Apparently my keyboard's battery must have died.
You need to remove that one here.
I think if I do that, it'll replace it.
Awesome. Thank you for answering questions about immigration. In your estimation, will priority date EB2, priority date May 1st, 2016, receive a green card in the next decade?
Well, I guess that's got to be India talking because, who else has such a terrible backlog? So for context, EB2 India is right now final action date for July visa bulletin on 1st of January 2013. So what that is 14, 15, 16, it's 3.5 years.
My answer to the question is yes.
It seems like a yes, but
that doesn't say anything.
Yeah, I mean, 10 years. So, I mean, I don't think we have a good estimation. I think we have a hope, and I think Sam and I are probably both in the category of, I really hope you're not waiting the next decade for a green card.
I honestly think that eventually things will get better.
Yeah.
With time, and there's going to be some change in the law that's going to be desperate because I don't think people will be interested to come to the United States unless this issue is resolved.
Yeah.
I
hope.
So
push the add button there.
Yeah. Let's go ahead and throw that one in there. Hello, Sam and Brian. If an ABC abandons the pending I-485 due to priority date when went back
retrogression.
And moving back to India, we file I-130 I45 again when priority date becomes current? Thank you.
ABC, and maybe my brain's not functioning.
When a person,
okay,
if a person abandons dependent 45 due to priority dates went back. So basically, let's assume somebody filed an I-130 to a green card holder spouse.
Yeah.
And they cannot continue to stay in the United States because they don't
have visa available.
So he leaves. Can he refile? Now you got I'm assuming. I mean, I-130. So this is a family-based case.
Yeah.
And if you have an I-130 filed and you're locked in the priority date, you don't have to file an I-130 again.
That's a good point.
But if the I-45 is denied or you withdrew it, and the I-130 is denied, you don't have a priority date. So you have to make sure that you have a priority date locked in place, which means you must have an approved I-130. I want to make sure because the I-130, I-45 threw me off a little bit.
Yeah,
do you have a spin on that?
I say my only spin is that sometimes withdrawn cases look interesting. You know, just obviously there's probably a very innocuous reason if you're withdrawing an I-130, for example.
Yeah.
I mean, we just help somebody withdraw an I-130 and I-45 because they said, my spouse and I aren't going to be in the U.S. for the next couple years. Why are we doing this? You know, there's plans changed.
Yes. All right. So, Brian, do you have any more questions for us today?
I think, well, let's check the live ones, because I would bet we don't have any more live ones, Sam. We only got through our content. We got through all the questions we have live on immigration and on immigration-questions.us.
Fantastic. So, well, thank you guys for listening to us today. We'll come back Monday at 6 o'clock Eastern Time and take one more topic. I think we're going to talk about something interesting.
I sure hope we do.
That is already brewing in the news.